Okay, welcome back. We are off the record. I wanted to share with you another story here, which is yet another utterly ridiculous story. I know a lot of what I say lately seems to be utterly ridiculous, but it really is. Now, this kind of story doesn't tend to do very well as a video on my main channel. Maybe you'll appreciate it here. I'm not sure why they don't do so well. Maybe it's because it crosses a threshold that annoys people just that little bit too much that they don't like to watch it. And I tend to find myself trying to analyze the YouTube algorithm a little bit to see what really works well. So maybe this will work well here. If you do like it, then do interact, like the video, share it, comment, make sure you're subscribed to the channel and all that sort of stuff. Every little bit really does trigger the algorithm if you like this kind of story. Now, this story, like many others, has reached the press because this case has reached the Upper Tribunal. That means it's been reported. There's a full tribunal decision about it, detailing all of the frankly ludicrous background of this story. And you can read it in full detail. Now, many people read the headlines and they think this must be exaggerating, but it's really not. It's really not exaggerating. This headline here says that this Pakistani man was jailed over a child bride migration scam and fights to return to Britain, and very often is using taxpayer money to do it. So when I read these things, I mean, there are certain headlines and stuff that are generally sort of trustworthy. Occasionally there will be mistakes and so on, but by and large, they are largely accurate. And it says here, it was an asylum seeker jailed for a sham marriage with a schoolgirl, has married her again in a bid to live in Britain. Nasir Khalil was imprisoned 9 years ago after he deceived a Slovakian child into coming to Britain for a Muslim wedding ceremony held 4 days after her 16th birthday. It says that he was 36 at the time, living in Rochdale, Greater Manchester. A jury found that he was part of a mail-order gang buying women living in the European Union who would then defraud the British immigration system by claiming that their husbands had a right to stay in the UK. Khalil was deported to Pakistan in 2019. The following year, he married the Slovakian, then 23, again, after she was granted indefinite leave to remain in Britain with their children. Now, make of this what you will, but let me dive to the immigration decision here, the tribunal decision. Now, there's an anonymity order for all but him, but it goes through in each detail and you can read it in full, and it is as the headlines suggest. Now, the reason that I say this is ridiculous is because the very factual matrix underlying this are so utterly grotesque that no one should ever have entertained any of this at all. And yet here we are with an upper tribunal decision, and some of it, which I didn't even read out from this bit here. Let me go back to the Telegraph article. This bit here where it says, the ruling shows that immigration judges accept his claim to be in a durable, loving and stable relationship with the woman who is now his visa sponsor, despite the fact that she is 20 years his junior and was a child victim of his crime, which he was convicted by a jury. Now, this is the tribunal decision. I kid you not. And so, again, like I say, these may be so outrageous that people don't like watching it on the main channel. Maybe because you're subscribed here to my Off the Record channel, maybe you are one of the few that who will absolutely want to subscribe to all my channels and really get to the bottom of these stories, because this is utterly horrendous. So let's go back and look at this tribunal decision here. Now, it says the Upper Tribunal is required to remake the decision in respect of this guy's appeal against the Home Office decision to refuse him a residence card, confirming that his unmarried partner of an EEA national exercising EU treaty rights in the United Kingdom. This was the second decision issued by the Home Office on his application. The Home Office, the respondent, I'm trying to sort of juxtapose here so it makes more sense. The Home Office previously accepted, and various judges have found, that he and his sponsor, the girl, well, she was a girl at the time, are in an ongoing genuine relationship amounting to, for the purposes of the immigration regulations, a durable relationship. He challenges the Home Office conclusion not to exercise discretion under the regulations, which in turn requires an assessment of the principles established by the regulations. He contends that the Home Office should have exercised discretion in his favour and issued him with a residence card. He also contends that the Upper Tribunal is required to consider his right to residence as a spouse of an EEA national exercising EU treaty rights. Remember, she was the victim of this guy as a child, which we'll come to in just a second. It is said that the Home Office issued a decision in June 22 that although the Home Office failed to consider that he, as a spouse of his EEA national wife, consequently a family member, she should have undertaken this task at the time of the decision. Now, it's paragraph 5 that sets out the background here. I'm not going to read the whole thing out, but paragraph 5 says, the appellant, this guy, was convicted by a jury of doing an act which facilitates commission of a breach of immigration law by an individual who is not a citizen of the European Union, contrary to Section 25 of the Immigration Act 1971. His sponsor, who will remain anonymous, who at the time was a child, was a victim of his crime. He was sentenced to a custodial term of 15 months in September 2016. After various unsuccessful challenges, he was deported to Pakistan in December 2019. She, the sponsor, is now lawfully present in the UK and resides with their children. Now, you can go through this in as much detail as you wish. Again, it comes back in paragraph 21. He stood trial, was convicted by a jury on one count under Section 25. In his sentencing remarks, having addressed the benefits to a non-EU foreign national in securing an EEA residence card and noting the concept of a sham marriage in domestic immigration law, the judge observed that a person could establish that they were a family of an EEA national by entering into a nikah to evidence a durable relationship. The judge identified the jury's acceptance that he entered into this marriage with a sponsor solely to deceive the immigration authorities, and he drew the inference that he deceived the sponsor, the girl, when entering the marriage. Though a genuine friendship had developed between the couple by this time, and his sponsor was attracted to him. Make of that what you will. The judge recognized that sham marriages have the effect of undermining the system of border controls in this country. And then in paragraph 25, his appeal against the decision to deport was eventually dismissed by the first-tier tribunal in October 2019. They said, we observe that the respondent accepted in her decision, the Home Office accepted in the decision letter, that he and the sponsor were in a durable relationship. So let's read that again, right? We observe that the Home Office, Home Secretary, accepted in her decision letter that this guy and the sponsor were in a durable relationship, as noted at paragraph 24 of the first-tier tribunal decision. We further observe that the first-tier tribunal conclusion that he did not enjoy the benefit of the exclusion regime established by the 2016 regulations because there was no extant application for a residence card, and there's case law supporting. In August, the sponsor was granted indefinite leave to remain, and he made a further application for a residence card, etc. At paragraph 90, it talks about his arguments and letters and such, and the technical arguments that he tries to make, obviously with lawyers, and I presume taxpayer funded, but I'm not certain about that. Paragraph 90 says, before us, this guy sought to rely upon his marriage and contended that it was not a new matter. He submitted the decision, did not recognise his right of appeal, and so on and so forth, despite different applications being used, and then says, this guy, the appellant, cannot bypass, as he seeks, the requirement as to the nature and substance of the application established by the Home Office, which is founded upon the Citizens' Rights Directive 92. There was no application validly made before the commencement day as required. In the circumstances, reliance upon the marriage and family membership can properly only be considered a new matter to which the respondent was not given consent. Underpinning our consideration above is that the email was sent by the appellant's representatives in June 22, long after the application for residence cards ceased to be permitted, legal arguments and such, and ultimately the decision is remade and the appeal is dismissed. So in other words, his lawyers argued, possibly at taxpayer expense, that he was entitled to a residence card as the spouse of an EEA national exercising EU treaty rights, bearing in mind this was the victim of his original crime. The judges, however, have rejected this claim, leaving him only one other legal route, an application for a family card, which is still pending, which he might get. Which is why I thought you might find this whole thing ludicrous. But what you might find even more ludicrous is the background story about how he came here and how his original crime unfolded. So for that, I'll go back to the Telegraph. So he arrived in Britain in 2012, having left Pakistan, to visit family, apparently in Rochdale. He was initially refused entry clearance, but was then allowed to stay for a short period. However, he failed to leave the country. After declaring that he divorced his first wife, who remained in Pakistan, he undertook a nikah, a Muslim wedding ceremony, which, for those of you that don't know, is not a legally valid or binding marriage under English law, with this girl in November 2013. The trial judge concluded that the girl received little or no instruction before the conversion to Islam, and the ceremony was not conducted in a language she understood. He tried to use his mail-order bride to claim that he had rights to remain in Britain under EU freedom of movement laws. A year later, he was arrested, prompting him to apply for extended family residence because his wife had a child. After that request was rejected, he applied again and was rejected again because he refused to provide necessary biometric information. In 2016, after being convicted of fraud by arranging sham marriages, Khalil fought deportation by claiming that he was now in fear of the Taliban in Pakistan. Despite a deportation order in 2017, it took 2 years for him to exhaust the appeals process before he was eventually returned to Pakistan in 2019. That year, his wife was given indefinite leave to remain in the UK before she travelled to Pakistan in 2020 to marry him again. He tried to use EU rules to return to the UK in 2020, but Priti Patel, the Home Secretary at the time, concluded that his character and conduct were not conducive to the public good because he tried to undermine and circumvent immigration laws. The latest ruling that his wife was a victim of Khalil's criminal offending, adding that she met the appellant, him, when she was 15 and they were married by an Islamic religious ceremony shortly after she turned 16. The sentencing judge concluded that the jury found that the appellant engaged with the religious ceremony solely to secure the status in this country, and consequently the sponsor was deceived when entering into the marriage. A spokesperson for BS Solicitors, which took on his case more recently, said an application for family visa based upon his recent legitimate marriage is currently before the Home Secretary. The Home Office has been approached for comment. So make of that what you will, but Priti Patel, Home Secretary at the time, made of it that it was not conducive to public good and that he sought to undermine and circumvent our immigration laws, bearing in mind how many years it took him to exhaust the appeals process, the sham marriage, which was then and is now being used as an argument for residence here, multiplied many tens of thousands of times over for anyone who seeks to use and abuse the same rules, the same laws, the same process, and potentially commit the same crimes and potentially abuse the process in exactly the same way. Now, as always, this is not to assume that everybody that comes here is going to do the same thing. This is one example that you hear about because it's made its way to the Upper Tribunal. And I feel it incumbent upon me, particularly on my Off the Record channel, to just talk freely to you about these things, that this is a waste of public resources, it is an abuse of our system, and as to quote the then Home Secretary, I rely upon that wording and that judgment to justify my view that this was not conducive to the public good and it is undermining and circumventing immigration laws. And this is still outstanding. We await now. We may not find out. If it's remade at a lower tribunal, we may not hear of this decision. We may not hear what happens. It may not reach the public eye. We may not hear anymore. We only hear of it because it's a decision of the Upper Tribunal. So do let me know what you think, politely and respectfully in the comments, please. And make sure you subscribe. And as always, thank you for watching.